My Lord, all the accused are present. A1 acts for himself, and the acting for A2 and 6 is Counsel Serwambala Julius. And Counsel Serwanga Geoffrey appears for A3, 4 and 5. A3, A4, 4 and 5. The matter is for judgment, my Lord. We are ready.
Yeah, okay. Mr. Nagirinnya, the little computer, the assessor is here. Mr. Congo Simon, Tony,
You're handling directors.
Okay, so now, this is the judgment of the court. This case is between Uganda for the prosecution versus Kasolo Priam alias Arsenal, Rebecca Johnson alias Fido, alias Eto, alias Manumanu, alias Rasta, Firi Kaliango Nasif, alias Moonge, Chiseka Hassan, alias Masada Mpanga Sharif, alias Shafiq, Katerega Sadat, alias Barrows. The accused persons are each indicted on 2 counts of kidnap with intent to murder under Section 243, subsection 1A of the Penal Code Act. 2 counts of murder under Section 188 and 189 of the Penal Code Act, and 2 counts of aggravated robbery under Section 285 and 286, subsection 2 of the Penal Code Act. It was alleged in count 1 that the accused person is on 28th day of August 2019 at Navisa Siro Zone, Rubaga Division, Kampala District, with intent to murder, forcefully kidnapped Nagirinnya Maria Gaten. It was alleged in count 2 that the accused person is on the 28th day of August 2019 at Navisa Siro Zone, Rubaga Division, Kampala District, with intent to murder, forcefully kidnapped Kitayimbwa Ronald. Is alleged in count 3 that the accused person is on the 28th day of August 2019 within the areas of Kampala and the Mukono district with malice aforethought killed Nagirinnya Maria Gaten. It is further alleged in count 4 that the above mentioned accused person is on the 28th day of August 2019 within the areas of Kampala and Mukono with malice aforethought killed Kitayimbwa Ronald. It is also alleged in count 5 that the accused person is on the 28th day of August 2019 within the areas of Kampala and Mukono district robbed Nagirinnya Maria Gaten of her motor vehicle registration number UBA 570V Spacio white in color, mobile phone IME number 362953044557610, and cash 260,000 shillings, and at or before or after the time of the robbery caused the death of Nagirinnya Maria Gaten. It is further alleged in count 6 that the accused person is on the 28th day of August 2019 within areas of Kampala and Mukono district robbed Kitayimbwa Ronald of his mobile phone Nokia serial number 3568399092, another 092020, and cash 24,000 shillings. And at or before or after the time of the robbery caused the death of Kitaimbwa Ronald. Representation A1 Kasolo Kopriam, alias Arsenal, opted to waive his rights to legal representation and chose to represent himself. A3 Karyango Nasif, alias Mwenge, A4 Chiseka Hassan, alias Masada, and A5 Mpanga Sharif, alias Sharif, were represented by Counsel Serwanga Joffrey, while A2 Rebecca Johnson, alias Eto, and A6 Hatela Gasadat, alias Barrows, were represented by Counsel Serwambala Julius Caesar. The prosecution was represented by Chief State Attorney Mwanga Timothy, Mwaganya Jonathan, and Senior State Attorney Counsel Timothy Amerit. The burden of proof in criminal cases, the prosecution has the burden of proving the case against accused persons beyond reasonable doubt. The burden does not shift to the accused persons. See the case of Wilmington versus DPP. Proof beyond reasonable doubt does not mean proof beyond a shadow of doubt. The prosecution evidence should be of such standard as leaves no logical explanation to be derived from the facts, except that either the accused committed the offense or is innocent. I mean, depending on what the case ends up, how the case ends up. The accused person should therefore only be convicted on the strength of the prosecution case and not the weaknesses in their defense. All the accused persons were found to be of normal mental state. And now, I'll proceed to resolve the matter. The offense of kidnapping with intent to murder, according to Section 243, subsection 1A of the Penal Code Act, for it to be proved, the following ingredients had to be proved by the prosecution beyond reasonable doubt. One, that there was the taking away of a person or persons in this case. Two, that the taking away was accomplished by force or fraud. Three, that the taking away was against the victim's will. And four, that the perpetrators of the offense were motivated by an intent to murder the victim or victims. And that the accused persons were the perpetrators of the said offense. Now, the element of kidnap or taking away a person, kidnap may be defined as the taking away or transportation of a person against that person's will, usually holding that person in false imprisonment or confinement without legal authority. This may be done for a ransom or in furtherance of another crime. There is a case of Uganda versus Musumami and two others to that effect. To prove this ingredient, the prosecution relied on the evidence of Senabulia Isaac alias Kisunsu, that was PWO 9, who testified that they found the motor vehicle of Nagirinnya Maria Gatende at the gate, hooting and about to enter inside the gate. He said that he found A1 and A2 who had been moving with him already inside the vehicle, and he also joined them inside. He said that inside the car was a male and female occupant. The father stated that They laid down the occupants in the rear seats of the vehicle and they drove the vehicle away from the gate. It was also the evidence of PW19 that the occupants in the vehicle were pleading with them to tell them the reason why they had captured them, but the police failed, but their pleas were ignored. Later, their bodies were recovered from Nachitulu Valley, Lokojo village, Mpoma Parish, Nama sub-county in Mukono. I find that this evidence is sufficient to prove that the victims were kidnapped. They were taken away and later they were found to be dead. Whether the kidnapping was by force and against the will of the victims, I shall handle these two together. According to the evidence of PW1 Isaac Elias Kisunsu, the victims were taken away by force and against their will, that they forced them to sit in the rear seat of the motor vehicle and drove away from the gate. He also told the court that the victims pleaded with them, but their pleas were not heeded. The fact that the victims were later found dead implies that they were taken by force and against their will. This fact was not disputed. I find that the prosecution proved that the victims were taken against their will, and the same was done by force. I will now also address those two elements. Whether the perpetrators of the kidnap were motivated by an intent to murder the victims, the intent to kidnap and the murder may be inferred from the fact that the victims were found murdered. In this particular case, PW1 and PW2, the medical personnel, gave evidence to the effect that the victims were brutally murdered. This evidence was corroborated by PW9, testifying that the victims were murdered using a log and a car jack. The eventual murder of the victims is sufficient proof that there was intention to murder them. Now, the aspect of participation shall be handled together for all the counts. Now, moving on to count 3 and 4. Murder. The offense of murder is said to be committed where any person who, with the malice aforethought, causes the death of another person by an unlawful act or omission. The following ingredients must be proved beyond reasonable doubt. 1, that there was death of a human being. 2, that the death was caused unlawfully. 3, that the death was carried out with malice aforethought. And 4, that the accused person is participating in the commission of the offense or are responsible for the death. The element of death of a human being. Death of a human being may be proved by production of a post-mortem report or evidence of witnesses who state that they knew the deceased person and attended the burial, also the dead body. This was held in the case of Uganda versus Mwesigwa, Jamada, and 3 others. The prosecution relied on the evidence of PW1, Dr. Moses Biaruhanga, a forensics pathologist and the director of health services in the Uganda Police Force, who testified that the deceased was identified by Dr. Ben Chuanuka, the uncle of the deceased. He testified that he examined the body of the deceased on the 31st of August 2019 in detail. This county is in respect of Nagirinnya on the internet. He testified that he examined the body of the deceased on the 31st of August 2019 in detail. PW described the injuries which were on the body of Nagirinnya. He stated that the cause of death was neurologic shock following blunt head trauma. The post-mortem report was exhibited in the court as Exhibit P1. The prosecution also relied on the evidence of Dr. William Omare Mutumba, that's PW to a pathologist to prove the death of Ronald Kitayimbwa. It only quotes that he examined the deceased. Kitayimbwa Ronald on the 1st September 2019, and his body was identified by one Rebecca Robert, a brother to the deceased. He found that the deceased person died as a result of head injury due to blunt force trauma. The post-mortem report was tendered in court as Exhibit 2. PW4, the war Francis Anthony, the biological father of Nagirinnya, Maria Gaten, also confirmed that Nagirinnya Maria had been killed. Most Cather Rollins, PW5, equally testified that Kitayimbwa Ronald had been killed and he was buried. So that was enough evidence to show death. To prove the death of Maria Nagirinnya and Kitayimbwa Ronald, beyond reasonable doubt, as to whether death was unlawfully caused. Any homicide, that is the killing of a human being by another, is presumed to have been caused unlawfully unless it was accidental or was authorized by law. See the case of R versus Gusambizi, son of Wesonga. To prove that the death was caused unlawfully, the prosecution adduced the testimony of Senator Isaac Elias Kisunusu, PW9, who testified that when they had reached at the scene of crime in Mukono along with A1, Kasolo Poporiniam, and A2, Lubega Johnny Manomano, A1 opened the doors of the car and picked out Nagirinnya and hit her with a car jack on the head. It was also the evidence of PW2 that A2 brought a big log and gave it to A1 who beat Kitayimbwa with it. The prosecution also adduced evidence of the post-mortem report of Nagirinnya Maria tendered in by Dr. Yaruhanga Moses, which indicated that her death was caused by neurologic shock following blunt head trauma, and the post-mortem report of Kitayimbwa Ronald tendered in by Dr. Miriam Mare Mutumba indicates that he died as a result of head injury due to blunt force trauma with considerable magnitude given the nature of the injuries. Each of the post-mortem reports clearly indicate the diverse injuries sustained by each of the deceased persons on their heads. This corroborates the testimony of PW9. The evidence as a whole clearly shows that this was not a natural or accidental death, but a double homicide or double murder. The death was caused unlawfully, and I find that the prosecution adduced sufficient evidence to prove this beyond reasonable doubt. As to malice aforethought, the law in relation to what is entailed by malice aforethought is settled. Section 191 of the Penal Code Act defines it either as an intention to cause death of a person or knowledge that the act causing death will probably cause the death of some person. According to the above provision of the law, the basic element in proving malice aforethought is the existence of an intention to cause death. There must be a premeditated or planned intention to cause death. In the absence of the accused person's premeditation to kill, the conviction cannot stand. Malice aforethought may be established when the harm is directed at a sensitive and vulnerable part of the body. This is because usually an attacker will not declare his intention to cause death or grievous harm. So whether or not he had the intention must be ascertained from the various factors which include the type and size of the weapon used in the attack, leading to the death of the victim, the amount of force used by the attacker on the victim, the part of the body of the deceased where the injury was inflicted. This was restated in the case of R versus Tubere, son of Ochen. It is an East African Court of Appeal case. Similarly, in the case of Nanyonjo Harriet and another versus Uganda, it was held that for a court to infer that an accused is killed with malice aforethought, it must consider if the death was a natural consequence of the act that caused the death, and if the accused foresaw death as a natural consequence of the act. The deceased Nagirinnya Maria Gateni sustained the following injuries as indicated in the post-mortem report exhibited in the court, that is Exhibit 1. She had an excessive intuition of the lips with lacerations. She also had a fractured right upper jaw with the fresh loss of 2 teeth. The report also indicated that she had a big stellate scalp laceration with a fractured skull. It was further indicated that the head and the neck had multiple fractures. The cause of death was neurologic shock following a blunt-headed trauma. In respect of Kitayibwa Ronald, the prosecution adduced evidence of PW to testify that upon examining Kitayibwa Ronald's body, found the following injuries, both internal and external. He had a depression on the skull. The right eye socket was collapsed, implying that the bones were fractured and almost inside the skull. The victim also suffered cut wounds on the face, which were bone deep. He also had laceration wounds on the forehead, which were skin deep. The victim also suffered multiple internal fractures, and the cause of death was an injury following blunt force. The nature of the injuries sustained by the victims are inconsistent with the evidence of, consistent with the evidence of PW9, who stated that the lady was hit with a car jack, while the man was hit with a log. The photo exhibits of the bodies were marked Exhibit P15 and showed the extent of the injuries. A horrific, the photos of the bodies were horrific. Actually, I'm unlucky that I had a glance at them, but that was my job. So I find that the prosecution proved beyond a reasonable doubt that there was malice aforethought in causing the death of the two. Now, for the aggravated robbery, the following ingredients had to be proved by the prosecution beyond a reasonable doubt. 1, that there was theft of property. 2, that there was use of actual violence at, before, or after the theft, or that the accused person has caused death to the victims. Then that the assailants were armed with a deadly weapon before, during, or after the theft, and then the participation of the accused persons. As to whether there was theft of property, theft occurs when a person fraudulently and with intent to deprive the owner of a thing capable of being stolen takes that thing from the owner without a claim of right. See section 254, subsection 1 of the Penal Code Act. Under section 254, subsection 1 of the Penal Code Act, the offense of theft is sufficiently proved upon proof of the fraudulent taking or conversion of any item that is capable of being stolen. In proving theft, there is no legal requirement to prove ownership. Once exportation or movement of the property takes place without the consent of the one in possession, then theft has occurred. See the case of Sulaka, Sira versus Uganda. To prove theft of mobile phones and the mobile money, the prosecution relied on the evidence of PW9, who testified that before the victims were killed, they took phones from, the perpetrators took phones from Nagirinnya, Maria Gateni and Kitaimbwa Ronald, but they forced the victims to disclose the PIN codes, that's the passwords of their mobile money and Airtel MTN mobile money and Airtel mobile money accounts that PW9 also told the court that it is PW2 who went with the phones to withdraw the money. That is Mr. Johnson Lubega. He also says that PW9 also testified that later they withdrew money from the phones of Nagirinnya and Kitaimbwa, and all of the accused persons shared it the following day from Mbabito in Atete. And that it was A1, okay. The theft has already been said, they stole the money and the phones and the vehicle and all that. That was the theft. The prosecution further relied on the evidence of Iga Disan, that is PW14, who stated that he is a mobile money operator. It was his evidence that on the 29th of August 2019 at around 5 a.m. while at his kiosk in Atete, A2 asked him to withdraw money from a phone. The phone in the money in the phone was 270,000, and upon conducting the withdrawal transaction, the phone of 80 showed the names of Nagirinnya, Maria. The agent line he was using was 07082189948, and the money was withdrawn from mobile line 074970863. The names of Nagirinnya, as I have said. The prosecution also relied on the evidence on the data analysis report tendered in by PW21, that is Baraza, as Exhibit 42, which indicated an Airtel money statement indicating that 260,000 shillings had been withdrawn from phone number 07049700863 on the 29th day of August 2019 at 5:55 hours to agent line 07082189948, which he later identified belonged to Disan, a money agent. PW14, that Igadisan also identified A2 as the person who came and withdrew that money. The prosecution further relied on the evidence of Wakubibwa Tom, PW13, who testified that on the 31st of August 2019 at about 6:24 p.m., a certain gentleman went to him and made a transaction on the mobile money. He withdrew 24,000 shillings on the line of Chitayimba Ronald, that when initiating or doing that transaction, the phone displayed the names of Chitayimba Ronald. That after completing the transaction, he gave him the 24,000. That is PW for 13 is the one who gave that gentleman the money. He said that his mobile money agent number is 0704 835 744, and that the number of the customer from which the money was withdrawn was 0755 848 732. The SIM card history of Chitayimba's line, as per the data analysis report tendered by PW 21 as Exhibit 42 indicated that after the crime, his phone was inserted in the phone handset number IME 1357360 10181734 on the 31st of August 2019 at 7:48:32 a.m. up to 1st of September 2019 at 4:36:40 p.m., during which money was withdrawn from it on the 31st August at 18:25 hours. This handset, according to the evidence of PW8 Frank Kairu, was recovered from Rebecca Johnson. The Airtel Money statement of telephone number 0755 848 shows that 24,000 shillings was withdrawn from it on the 31st of August 2019 at 18:25 hours to agent line, which I've already mentioned above, 0704 8354 744, who were identified to be of Wokbibwa. To prove theft of motor vehicle registration number UBA 570V, the prosecution relied on the evidence of Sanabria Isaac, PW9, who told the court that on the night of 28th August 2019, they found the said motor vehicle at the gate and forcefully accessed it and drove away with its occupants. The person who drove away the motor vehicle had no claim of right over it. Other occupants had been kidnapped. We've already found that. PW9 further stated that it was A1, Mr. Kasolo, who drove away the motor vehicle up to Mukono, where they later murdered Nagirinnya and Chitayimba Ronald from. The printed image of motor vehicle registration number UBA 570 was admitted as Exhibit P14. Defense Sergeant Barasa T. James, PW21, stated that the motor vehicle, Espacio white in color under registration number UBA 570, belonged to Nagirinnya Maria Gateni. He also testified that on the fateful night of 28 August 20, it was Chitayimba Ronald who was driving the said motor vehicle, while Nagirinnya Gateni was seated at the front as a passenger. Later, the vehicle was taken from them and they were kidnapped along with that vehicle. The prosecution also relied on the evidence of SP Ogwanga Nixon, PW19, who testified that the motor vehicle the photo admitted as Exhibit 14 was taken and captured by an ANPR, that's the automatic number plate registration camera at Chinawataka at 05226, and the motor vehicle was captured while it was being driven by a man towards Chireka. That man was identified by PW9 to be A1, that is Mr. Kasolo. PW9, remember, was unaccompanied, he was with them. PW9 told the court that the motor vehicle was abandoned at Chigaga in Natete. The evidence is corroborated by the evidence of Kawiye Wodala, PW6, informed the court that on the night of 28th to 29th August 2019 at around 2 a.m. he saw the motor vehicle being parked and abandoned at Chigaga zone. He described the motor vehicle as a white Spacio. From the evidence adduced by the prosecution, I found that there was theft of motor vehicle registration number UBA 570V and mobile phone is referred to, that is IME number 86295 304455 7610. Then cash 260,000 shillings, all belonging to the deceased Maria Nagirinnya. Also find that there was theft of a mobile phone Nokia serial number 356 839092092020 and cash 24,000 shillings belonging to Saimbwa Ronald. This gradient was therefore proved by the prosecution beyond reasonable doubt. Now, use of actual violence at before or after the theft or causing death to the victims. And the prosecution relied on the evidence of Senator Isaac, who stated that when they rode to the home of Nagirinnya, they found the motor vehicle of Nagirinnya at the gate, entered it and forcefully, and with the aid of A1 and A2, forced the occupants in the rear seats and sat them on them, and he drove away. PW9 also stated that at the murder scene in Mukono, A1 with the aid of A2 used the log to beat Kitayimbwa, while A1 got a car jack from the boot and started hitting the head of Nagirinnya until she died. Even the photos of the deceased person is tendered in as Exhibit 15, painted a gruesome picture as to the violence occasioned on the victims. The car jack was tendered as Exhibit 28. The violence meted on the victims led to their death, as clearly indicated in the post-mortem reports. PW9 also told the court that before the victims were killed, they took the phones from Nagirinnya and Kitayimbwa Ronald. It was also his evidence that they forced the victims to disclose the PIN codes, that's passwords of their mobile money accounts. That is Airtel accounts. And they did that. Well, he stated that it was A2 I find that the prosecution has proved beyond reasonable doubt that there was use of actual violence during and after That is during and after the robbery. But also, it has also been established that there was a death that was caused to the victims. So that is also another ingredient of the offense of robbery. So now we have seen that all the three offenses were committed, each against each of the victims. So for each offense, it was committed 2 times against each victim. I'll now deal with the participation in respect to all the counts. Now I'm handling the issue of participation. Participation of the accused persons may be proved by direct or circumstantial evidence placing them at the scene of crime at the material time. The direct evidence would be the testimonies of the witnesses who claim to have seen or identified the accused persons in the course of commission of the said offences. In examining this issue, the court must examine all the evidence closely, bearing in mind the established general rule that an accused person does not have to prove his innocence. It is up to the prosecution to disprove the defense of the accused person is by adducing evidence that shows that despite the defense, the offense was committed and was committed by the accused person. You see the case of Secretary versus Uganda. In their defense, A1 raised the defense of alibi and stated that on the 28th day of August 2019, the day the alleged offenses were said to have been committed, he was at his workplace at Mabito in Natete. It told the court that he is a hawker who works in the night. It was his evidence that he came to Mabito at 7 p.m. and left the place at 7 a.m. the following morning. He also denied the rest of the accused persons, except he also denied knowing the rest of the accused persons, except Katerega Sadat, whom he was living with. A2 raised an alibi and stated that on the 28th of August 2019, when the alleged offences took place, he was singing Alaza pub at Salama Road in the Kampala district between 10 p.m. and 12 a.m., after which he went to Vox in Maki, India to relax up to 6 a.m., after which he went home. A3, Karyango Nasif alias Muonge testified that on the fateful day, he was at Alex's shop and one of the border riders by the names of Kiseka Hassan came to him with 4 other people, and they wanted to take them, and he was alone. He admitted riding A1, A2 and PW9, but stated that he did not know their motive. A4 Kiseka Hassan alias Masada opted to keep quiet. A5 Mpanga Sharif alias Shafiq testified on the 40th day he was coming back from taking a passenger to Mulenga when Karyango Nasif called him using a mobile number which was not his, informing him the telephone number was not known to Mpanga anyway. He didn't know it to belong to Karyango Nasif. So he was informing that he had some passengers to carry and needed help as he could not carry all of them. He admitted carrying A1, A2 and PW9 by saying that he did not know their motive. A6 denied knowledge of the charges against him and stated that he was arrested because A1 had led the police to his place. The legal position with regard to an alibi is that there is no onus on an accused to prove it. Once the accused person raises an alibi, the evidential burden shifts back to the prosecution to disprove that alibi. The accused person, therefore, has only to raise the alibi, but has no duty of proving it. The prosecution bears the duty of destroying the defense by putting the accused at the scene of crime at the time it was being committed. See the case of Ogere versus Uganda, Ogere Moses versus Uganda. The defense of alibi does not have to be considered in isolation. The court must consider the alibi in light of the totality of the evidence in the whole case. And the court's impression is of the witnesses. The defense of alibi would naturally dissipate upon the adducing evidence of the identifying witnesses placing the accused person is at the scene of crime and the material time. To dispute the defense of alibi, the prosecution relied on the evidence of PW 9, Senator Isaac Elias Kisunsu, who testified that while at Natete, Kasolo Priam A1, together with the Mano John A2, went to him and told him to join them and they get some money. That they went along on motorcycles with Muonge, that is A3, and Ipanga Sharif A5. That they found the motor vehicle of Nagirinnya Maria Gatenyi at the gate, hooting and about to enter in the home. That he found A1 and A2 already in the inside the motor vehicle and told him to join them inside. He said that inside the car was a male and a female. He stated that they laid the male and the female occupants down in the rear seats of the motor vehicle and they sat on them together with A2. He further told the court that it was A1 driving the motor vehicle. It was also his evidence that the victims pleaded with them, but A1 silenced them. And they drove up to Mukono, where they were later murdered from. The prosecution acknowledged that the offense occurred at night, but contended that the circumstances were favorable for the correct identification of the assailants. In the case of Moses Bogere and another versus Uganda, Supreme Court criminal case, criminal appeal number 1 of 1997, the court outlined the factors for correct identification to include the length of time the accused was under observation, the distance between the one who was observing and the one who was being observed, the light that was there at the time of observation, and the familiarity of the witness with the one who was being observed. PW9 was an eyewitness and part of the assailants who directly participated in the commission of the offenses, right from the planning, the movement, and execution. He knew each of those people, how they dressed, and gave a detailed account of the role played by each of them. At both the scene of kidnap and the murder, his testimony was that he was aided by light from the motor vehicle to see whatever was taking place. He was physically present at each event and was in close proximity. The direct evidence of PW9 is therefore relevant to the defense of alibi raised by A1 and A2, and it places them at the scene and positively identifies them as the person who committed the said offences. To corroborate the testimony of PW 9, this is not a collaboration now. F3 is also an accomplice, so it cannot be corroboration. So to support the testimony of PW9, A3 testified that he met A1, A2 and PW1 on the night. It was his evidence that he rode A1 and A2 while PW1 and another still at large sat on A5's motorcycle. That when they reached Sega, A1 and A2 went and sat on A5's motorcycle because the motorcycle of A3 had developed a mechanical problem anyway. He said that he closely followed them with the PW9 to Lunguja. That was now A3 testifying. He further stated that at Lunguja, a motor vehicle came, flashing lights, and stopped before them. It was his evidence that A1 was inside the vehicle and that he stopped them. He added that this vehicle stopped and A1 opened the door and told the PW9 to enter the vehicle. That A1 immediately drove away. In his evidence, he clearly described A1, A2 and PW9 and how they were addressed. He was able to properly identify A1 and A2 as he met them, as he had met them before. That is earlier. Further, as A5 testified that at about 10 p.m. on that night, he rode A1 and A2 on his motorcycle to Lunguja. He told the court that on the night after carrying A1 and A2, he received a call from someone asking him to go to Namangwe and pick them up. He told the court that he wasn't sure who it was, but the person introduced himself as the people he had earlier on carried to Kalerwe and Lunguja. It was his evidence that he rode up to Weogenere, and when he reached there, they told him that they had gotten someone else to carry them. A1 further testified that A2 lied when he told the court that he had never carried them on that night when the offences were committed, and that he did not know him. He lied. He said that he lied to that effect. To the contrary, A5 sufficiently described how A1 and A2 and PW9 were dressed on that night. His evidence dispels the claim by A1 and A2 that they had never seen him and directly places them at the crime scene, contrary to their defense of alibi. In an attempt to dispute PW9's evidence in a chief implicating them, A1 and A2 testified that they did not know him. They said that PW9 was a police officer who had tortured them while in custody at Katwe police station. I found this not to be true because the evidence of PW9 is corroborated by that of A3 and A5, who stated that they had carried the three of them at night on their motorcycles. And the story of PW9 actually matches that of the other witnesses. So these people saying this man is a police officer who tortured them. Yet others are saying, but we were together, all of us with these people were saying he's a police officer. I think that one, the story of A5 and A3 makes more sense. Actually, those two witnesses unequivocally stated that PW9 has never been a police officer. The evidence of PW9, A3 and A5 is essentially accomplice evidence. The law with regard to accomplice evidence is provided for under Section 132 of the Evidence Act. It provides as follows, that an accomplice shall be a competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. While the court may convict on uncorroborated evidence, uncorroborated evidence of an accomplice, it is normally desirable that such evidence is corroborated with some other independent evidence. The corroboration which should be looked at is as laid out in the case of R versus Bascavel, that is 2KB 658. Some additional evidence rendering it probable that the story of the accomplice is true and that it is reasonably safe to act upon it. It must be independent evidence which affects the accused by connecting him or tending to connect him with a crime, confirming in some material particular not only the evidence that the crime has been committed, but also that the accused committed it. To corroborate the accomplice evidence, the prosecution relied on the evidence of Detective Assistant Superintendent of Police Nakatude Winifred, PW 15, who recorded a charge and caution statement of A1. The court conducted a trial within a trial and came to a finding that the charge and caution statement of A1 was obtained voluntarily and the accused was not tortured and coerced to record it as he claimed. The original Luganda version of the charge and caution statement and the English version were tendered in court and admitted as exhibits in evidence and marked exhibits P19 and P20 respectively. In that charge and caution statement, A1 confesses unequivocally his participation in the kidnap with intent to murder, in the murder and aggravated robbery of Nagirinnya, Gatenyi and Chitayimbo Ronald. A1 also confesses that A2, A3, A4, A5, A6 and A8 all fully participated in the commission of the offences and disclosed the roles of each participant. Detective Sergeant Baraza, PW 21, testified that he interviewed each of the accused persons and A1 admitted to have led his colleagues into the commission of the kidnap and murder. He testified that A1 mentioned Rebecca Johnson, commonly known as Rasta, that is A2, Mpanga Sharif, A5, Katerega Sadat, A6, Karyango Nasif, A3, Kisaka Hassan, A4, Sendaula Isaac, Chisunsu PW9, and Evan Fred, whose whereabouts are still unknown. PW21 also testified that he interviewed Kalyango. Okay. And Chief A3 alias Mwonge, who admitted playing a part in the kidnap and the murder of Nagirinnya and the Kitayindra Ronald. He further testified that he interviewed A2, who revealed to him one of the pangas which was used in the commission of the crime and where it was kept. PW21 also testified that A1 Kasolo identified to them Chisaka Hassan, that is the A4, as one who was part of them. Well, PW21 also stated that A5 admitted taking part in the kidnap and murder of Nagirinnya and Chitaimbwa. Further testified that Kalyango Nasif revealed having used a motorcycle to carry Kasolo Koperiam and Rebecca Johnson to the scene. Well, that one, they testified even in their defense. They gave that testimony, so it is not special. Now, number 40132, Detective Koporo Osekenya Michael joined a team of investigators who were led by the chief persons for a scene reconstruction. He recorded the video which captured A1, A2, and A3 making voluntary narrations of how they committed the offenses at the various scenes of crime. Section 29 of the Evidence Act provides, notwithstanding sections 23 and 29, any fact is deposed to, as discovered in consequence, any fact